Hi everybody, it's Wayne Jones, the course coordinator for employment law. This is week 2 and part 2, and can I say at the outset there's some really interesting cases in the material this week. I'll give you a brief overview. The details of the cases appear in your textbook, and also the citations will appear on my slides. You remember in the first part of week 2 we were talking about the difference, essentially the difference between employment and contracting. And one of the interesting things about the difference was that there wasn't any definition from the statute, so we couldn't look up a definition of either employment or contracting in the Fair Work Act. We needed to go to common law. Well, the same for some of the concepts this week, particularly around what makes an employee a full-time employee and what makes an employee a casual. Again, no definition in the textbook, and we need to go to the common law. So some interesting cases, and I would urge you to have a look at them in more detail. Okay, as I've said, it's week 2, part 2. We're looking at types of employment this week, and you'll need to have a look at your textbook, Stewart's Guide, read chapter 4. Now, let's talk first of all about full-time or part-time. Interesting concept, and for some of us we use different terminology. Full-time, part-time. Full-time can be at the university, for example, a person who is here every day of the week, or they might have what's called a fractional appointment. But the point is that they still fall into the category of being a full-time employee when you're comparing them to a casual. A casual is essentially somebody who works on a very informal, uncertain or irregular basis. Now, one of the cases we'll talk about a little later, for example, a woman worked at a hotel, and it was very clear when the court had a look at the circumstances under which she worked, she was really able to call the shots as to whether she wanted to take up a shift for that week or not. So it had all that informality, informal, uncertain, irregular. Think about the people, for example, who'd work at a little fish and chip shop at the North Coast. They would work probably on that same sort of informal, uncertain, irregular basis because during the holiday period, the shop will be incredibly busy. And then once you get past Easter, into the colder months of the year, probably not so busy and not so much call for employment, particularly casual employees. So the work would drop away. They'd be called in when they were required. There is an award definition of a casual, and it's quite interesting from this perspective. It says specifically engaged and paid as a casual, which doesn't mean much at first blush, but when you think about it, what that means is that the employer has the discretion to decide whether a person is going to be characterised as a casual. So the basis on which the person was engaged and paid is the determining factor in a lot of the modern awards. So if the award says casual, they mean specifically engaged and paid as a casual. If you have a look at the case of Reed against Blue Line Cruises, for example, one of the cases that was given to you in your textbook, that was a fellow who did the work driving a cruise boat on the harbour, and his employer said to him, well, there'll be sometimes it will be very busy and other times when we won't. And in fact, even his letter of engagement talked about the fact that he was being engaged and paid as a casual. It was an informal, uncertain and irregular basis. Do note the commentary in your textbook though. Sometimes even where the contract refers to the fact that the person is to be a casual, if it's lacking that uncertain and irregular basis of employment, a court can come over the top and say, well, look, we think you're still entitled to holidays because you've got a roster set out ahead of you for the next 12 months, so there's really nothing uncertain, informal or irregular. And so do have a look at those couple of cases that get a mention in the text. A casual will receive 25% more pay each hour than a permanent. So there's got to be some payoff for that. What reason would an employer pay a person on a casual rate? And the answer is that rate, that 25% extra, includes annual leave, paid carers leave, and the fact that there's no period of reasonable notice for termination. So if a person is truly a casual, they don't receive any of those things, and instead they're compensated by receiving 25% extra pay in their packet each week. So are there any statutory rights at all that are left for casuals? Well, in certain circumstances, and I will ask you to have a look more closely at your textbook, in certain circumstances it's fairly clear that casuals may be entitled to long service leave. Now, clearly we'd be talking about somebody who needed to be employed for the usual period of time, so usually that's something like 10 years, and I think in some states once a person reaches a threshold, and that might be as short as 8 years, they start to become entitled to long service pro rata. So the person would need to have worked on a casual basis pretty regularly for that long. They might be entitled to long service. In some cases, there is an entitlement to bring a claim for unfair dismissal, and that's, if you like, just stepping back to what I was talking about before, where you might have a permanent casual, somebody who's working just week after week. If they have a reasonable expectation that that employment should continue, or could continue, they may be able to bring an unfair dismissal claim. And they certainly can bring a claim for flexible working hours, provided they've been working at the place of employment for the requisite time. And the section for that in the Fair Work Act is section 65(2)(b). Just have a look at the two cases that get a mention. Both interesting in as much as in the Flinders Port case and Woolford, the worker was working casually on the docks, worked there for a few years, at least 3 or 4 years, and then was off for a considerable period of time on workers' compensation. So you'd think it might have been a bit of a long bow to draw to say that, okay, well, I want to add the time that I worked plus the time that I was on compensation, add those periods together so that I become entitled to long service. And the courts said no, they just looked at the time that the person was actually working. But no problem at all giving a casual long service in New South Wales. The other one, Thompson against Big Bird, again, quite an interesting case. Have a look at it, even if you just have a scan through the case. Thompson against Big Bird Proprietary Limited. This was the case of bar staff, a lady who'd worked at a hotel for quite a few years. She made a claim because she alleged that she was sacked because of her age. She'd heard the manager say, it's about time we got rid of some of these old staff and get in some young glamours. That was the words that she said he'd used. So it was essentially a discrimination claim, but again, the court had a look at whether or not this casual person could make a claim for unfair dismissal. And they said, in some circumstances, that's entirely possible. All right, now another type of outworker, another type of worker is an outworker. That's a person who works not in the usual working premises, but in fact might, for example, be working from home. And they are, for the purposes of the Act, deemed to be employees. If I think about it, I suppose my argument would be that they are treated differently, picked out by the Fair Work Act and deemed to be employees because they have been in a very terrible position in the past, out of sight, out of mind. You'll hear talk about workers being sweated in sweatshops, and unfortunately employees, particularly outworkers in textile clothing and footwear, were taken advantage of and probably are still being taken advantage of in various workplaces now. How the legislation reacted to the position of these outworkers was to say, firstly, we might deem you to be an employee. So even if you look like a contractor, we're going to deem you for the purpose of the legislation to be an employee, so that a lot of the benefits that apply ordinarily to anybody who's an employee will apply to you. And secondly, in recent times, there's been some legislation which gives the deemed employees the right to sue somebody further up the chain if the company above them goes broke. So typically what might happen is an outworker might not be paid, and the company that employed them goes into liquidation saying, well, we can't afford to pay you, leaving the companies further up the chain to have the benefit of the work that's been done but not have to pay. And so the government has enacted legislation that suggests that supply chain employers a bit further up the chain may very well be liable for outworkers' pay, superannuation, etc., where the person directly employing them has gone broke. Now, we need to talk about labour hire because it's such a growing part of the employment landscape these days. Labour hire is not recruitment. Recruitment is where somebody finds a suitable candidate for employment in your business. Labour hire is where the hirer has a contract directly with a company which is looking for a temporary workforce, if I can put it that way. They want a workforce for the moment, but they might not want it a little further down the track. So they go to a labour hire company which will have employees on their books available for hire. The labour hire company has the ongoing relationship with what's probably a very mobile workforce. People will come and go and put their name down with the labour hire company. They are temporary in the sense that if a host employer, and that's the employer that has the contract with the labour hire company, if for any reason they're unhappy with a particular worker who is supplied to them, they really don't need to explain themselves. They can terminate that arrangement and say to the labour hire company, we want you to send someone else to us. They don't need to explain why that's so. Although usually they'd be saying to the labour hire company, well, we're not satisfied with their work or what have you. So there is never any contract between the worker and the host. And you'll see from your textbook reading that none will easily be implied either. There is an example given, but it's not. It's really not a case that tends to show that the courts will step in and imply such a relationship. I think it was just a disorganised employer who wanted to move to labour hire and did it badly. And importantly, of course, with labour hire, workplace health and safety rules still apply. Remember I said to you previously that the workplace health and safety regime spreads a fairly wide net, even applying to visitors to a site. So it's not unusual to think that, okay, even the host employer is going to be primarily liable for injury to a worker who's injured at their site. Now that employer, of course, will be covered by workers' compensation insurance, but when it comes to working out who's responsible for the injury, the hirer, the host agency, doesn't get to say, not our worker, not our problem. They still are liable to maintain a safe workplace. The labour hire companies will most usually operate on a casual basis. So they'll have people on their books and they will offer them work as and when they have a contract to fill. Sometimes some of the more unscrupulous agencies, I think, will try to get a round peg into a square hole and insist that the worker is not a casual but is in fact offering themselves up as contractors. 2 comments about that. Have a look at the cases that get a mention in your textbook because they're both pretty terrible, I think. One is a tomato picker who's supplied to a tomato grower to pick fruit. You could hardly think of a less likely candidate for somebody who was operating their own business, except perhaps for the next case, which was Fair Work Ombudsman against Contracting Solutions, and that's the case where the young 15-year-old shop assistant was supplied by the labour hire company. Yes, have a look at both of those cases, and in the context of those two cases, just be aware that the Queensland State Government is currently investigating what it calls rogue labour hire operators. You'll see a mention, there's a short extract from a press release from the Treasurer, the Honourable Curtis Pitt in Queensland, who's also the Minister for Employment and Industrial Relations, just saying we're looking at making sure that employers are complying with Queensland's workplace laws and they're not being exploited. And they're referring there to a cucumber picker in Bundaberg being paid under the award. All right, that brings us to trainees and apprentices. Now, just a reminder, we're talking about different types of employment, special types of employment. Last time round, we talked about the difference between employment and contracting. Now we're talking about special types of employment. Well, certainly traineeships are a very different type of employment. Usually a young person, but not so much these days. It can be an older person, but usually school leaver, younger person, accepts a lower training wage. They accept less money on the basis that they're still going to work hard, but they're going to exchange that for training and experience on the job to learn a trade, to learn how to be a carpenter or a plumber, etc. Something like that. So that sets the stage for things. Now, apart from accepting a training wage, the second thing is to determine, well, what's different about them so far as employment is concerned? Are they still employees? And of course the answer is yes, they are very much still employees. They're a special type of employee, but they still have the entitlements of every other employee. So they're entitled to a minimum wage. Awards and enterprise agreements still apply to them. So the enterprise agreement that applies generally within their business will apply to them. And the only slight change to that is the Fair Work Act says that they are employees and that state laws don't apply except so far as training is concerned. Now, it's a bit of a tangle. You might have to have a closer look at it. But if I refer to Section 29 of the Fair Work Act and then Section 27(1) of the Act, you'll see what I'm talking about. So Section 29 talks about the interaction of modern awards and enterprise agreement with state law. And it says that, essentially says that modern awards or enterprise agreements prevail over state laws. And you'll remember that Section 27 talked about some excluded, it spoke about excluded exclusions from that, and they were things like equal opportunity and anti-discrimination laws, etc. But there were some non-excluded matters, and they included in Section 27(2)(f) training arrangements, except in relation to terms and conditions of employment, to the extent that those terms and conditions are provided for national employment standards or might be included in an award. So you've got this situation where, so far as the Fair Work Act is concerned, state acts don't override awards and conditions governed by the Fair Work Act, except so far as they relate to training, because they're a non-excluded matter. But what they're talking about there particularly are not so much the terms and conditions of the employment, but the fact that the person who's an apprentice, for example, may have a training agreement. The employer may have a training agreement. these agreements are made under state legislation. They're still allowed to be made under state legislation. They can be suspended, they can be terminated, but they don't infringe the Fair Work Act legislation that says only the Commonwealth can make laws with respect to employment. The Commonwealth also looks after trainees in this way. First of all, it offers incentives to employers to take on trainees, so it actually pays employers to take them on. And secondly, it provides money for training, but it does so on the basis that the training meets a certain level of skill. And I've put up there the slide from the Australian government's Australian Skills Quality Authority. Now, they've had their troubles over the years, and there've certainly been rogue agencies that haven't done what they're supposed to do. But essentially, the Commonwealth is trying to make sure that state-run providers at least maintain a certain standard so that apprentices and trainees get some good quality training. So just remember, so far as the Fair Work Act is concerned, trainees are still an employee. Therefore, they do get the minimum wage. There's no free training periods once they're started, and awards and enterprise agreements apply, subject to training laws. All right, I want to talk about public servants. You'll see in the textbook it's reference to the historical situation, which was that all public servants were employed by the Crown and could be not only employed but dismissed by the Crown. You were said to be employed at the pleasure of the Crown, and that's really shrunk back a long way now to just judges and magistrates. Judges and magistrates are said to be appointed, and they take a commission. You'll hear also the same terminology in the armed forces, that someone receives a commission from the Crown. Generally, all of the statute laws that apply to most workers apply to members of the public service now. We talked in the first week about coverage, so you'll know that, for example, in most of the states other than Victoria, public servants their employment terms are regulated by the state, but generally all the statute laws that would apply to any other worker apply to public servants. There is a general assumption of an entitlement to procedural fairness, and I'll just take you back a slide to a note I'd made there about the Queensland Public Service Commissioner. In Queensland, for example, there is a public service commissioner who has oversight of the way the public service operates, and it's to the public service commissioner that various bodies can appeal to have a decision taken. But public service commissioner, for example, is responsible for coming up with a decent in-house code of conduct. It formulated a code of conduct for how public servants should behave within the workplace. So there's this oversight by a public service commissioner. Have a look also at the Queensland Public Service Act, which provides some overarching protections for public servants. But look, generally speaking, notwithstanding this idea that public servants work for the Crown at the pleasure of the Crown, there is still an assumption that people won't lose their job, they won't be disciplined, etc., except where procedural fairness is followed. Finally, I just want to mention volunteers. In your textbook, there are two issues surrounding volunteers that are worth a mention. One was this idea that volunteers are volunteers because there is no contract of employment. If you think back to, again, to the first week when we talked about forming a contract of employment, and we will talk more about it next week. If you think about it, a contract of employment, I said to you, is like any other contract. There has to be some sort of consideration flowing, and offer and acceptance, I guess. I'm offering to work for you and you've accepted it. The terms, including my terms of pay, have been sorted out. And there's an intention to create a legal relationship between the parties. In this case, an intention to create a relationship of an employment contract. That just doesn't apply here. The expectation is that people are doing something for other motivations other than payment. Workplace health and safety still applies for the reasons I mentioned earlier. Discrimination laws still apply, so a person can't be victimised, can't be discriminated against, they can't be sexually harassed. And each of the parties really owes the other a duty of care. The would-be employer, or I don't know what we call them, perhaps the host organisation that has the volunteer, is meant to look after the person while they're on the site and make sure that they're not injured. And of course the person who's doing the volunteering has a duty to do their best and not injure the business of the organisation that's taken them as a volunteer. The second issue around volunteering, though, very interesting one about whether an organisation can ever expect there to be unpaid work involved in what people do. Two interesting cases, but I can think of other examples where people have been told that they're expected to provide a certain amount of unpaid voluntary work. But the two that were mentioned in the textbook are quite interesting, and I would recommend you look at them. In Smith and Amart All Sports, there's this what was described by the judge as a Dickensian expectation that workers would voluntarily want to give up an extra 30 minutes at the beginning and at the end of their shift each day and work for the good of the company. They were fined over $50,000 for requiring workers to do that. And interesting case, do have a look at it. You can see that no one's really taking responsibility. Certainly the head company was saying, well, we didn't know anything about it, although there is some evidence that various trainers had been through the place and had heard about it. Second, a bit more complex, that was the case of Neil and Matheson. She used to work in the shop. The respondent in this case was a husband and wife that just owned a little corner shop, and Matheson worked there pretty much on a friendship basis. She got the job on a friendship basis. Then she separates from her husband and she starts to live in the little flat out the back, and they become quite close, and then they talk about her being able to move into a house that they have, and of course it all goes sour eventually. Now she went from being a wage employee to receiving just a really modest amount of, I can't remember now, I think like $50 a week, something like that, plus she could have a packet of cigarettes every day, and goodness knows, probably 8 out of the shop as well. Very, very interesting though, because after a number of years of not being paid, the court ordered that the employer, because they found that they were employer, ordered that they pay over $450,000 in back pay and interest and etc. to the worker. So quite an interesting case. Have a look. There is another one there that rates are mentioned, Kimberley Child and Family Centre. Look, have a look at that one for yourself. It's more about the situation where when an employee is working for an agency that's pretty much a government-funded voluntary agency, and they're aware that occasionally funding runs out, it is quite okay for them to volunteer and not get paid. All right, well that's my comments on what I thought was an interesting part of this week, and that is the different types of employment. Next week we'll talk about creating an employment contract and what are some of the terms. Again, some interesting cases in that, so join me then.